Lawyers don't often go to war with judges, but when they do, something big is happening behind the bench. This is the full story of why multiple defense attorneys turned against Judge Stephanie Boyd, accusing her of bias, disrespect, and using the courtroom spotlight for her own gain.
Sure, she goes through her comments, right? She sets up her handbag next to her flower display, and she goes through a series of, I'm going to call them ovations. Most have jest packed into them to get laughs, either online or in the courtroom, before she actually calls the docket and begins serious business.
Don't forget to like and share to help stories like this reach more people. June 23rd, 2023. Melissa, a 46-year-old woman with schizophrenia, was scared. She thought someone was watching her. Within minutes, 3 officers entered her apartment. Melissa was shot and killed. The public was outraged. For the first time in decades, 3 San Antonio police officers were criminally charged. 2 with murder, 1 with aggravated assault. Judge Stephanie Boyd was assigned the case. Known for her no-nonsense courtroom, she was determined not to let the trial drag. From the beginning of 2024, delays started stacking. Defense attorneys claimed they were unprepared. One had been hospitalized. Another lost a family member. Experts were unavailable. Discovery was incomplete.
All right, today is the plea deadline date. Have you all reached an agreement or no?
I've extended an offer to this defense, Your Honor. Don't believe they're accepting.
Yes, y'all want a jury trial?
We do, Judge.
All right, Ms. Ferguson, I need a jury trial date. How long is this trial going to last?
Logistically, I could say in upwards of 3 weeks. Judge.
No. How many witnesses y'all have?
State anticipates, of my initial witnesses, approximately 25 right now.
All right, so some of those witnesses, I don't think they're probably going to be 25.
Judge, can I speak
Yes.
on it a little bit?
Mhm.
There's a joint defense agreement in this case.
Mhm.
So when I say logistics, I'm referring to not only space, but also time. We're gonna have to accomplish a counsel table or an area that can accommodate 3 lawyer teams and their respective clients.
All right, so when you all say 3 lawyer teams, I can tell you all the space, turn around, the space that you see in this courtroom is the space that you will have. So if lawyer teams want to bring paralegals and everybody else, they're going to be sitting somewhere in the gallery.
Well, let's just assume for a moment that there's 1 lawyer with each client. We know there to be more.
Mhm.
I don't know how you set 6 grown men at that one little table.
You all
Just
gonna have to
putting it before
squeeze
the
in.
court.
I understand. You guys will have to squeeze in. Guess what? This is what the county has available. This is what the county is paid for.
Which is why we're bringing it up. We're curious what else the county has available. Other
Oh,
courtrooms
just
that are
this.
larger entities. Well, I think there's other ones, and so we'd like to explore those possibilities. We wouldn't want it to prejudice the clients or the presentation of the evidence at all. So we're putting it before the court early, in earnest, wanting to be candid with the tribunal and then hopefully
I
find.
appreciate that, but what I will tell you all is judges rarely, if ever, agree to switch courts. So this is where we are. Yes.
And Your Honor, I do not mean to interrupt. I do have an issue that has been pursued. As the court know, we met the discovery deadline at the end of May. There has been an issue that the state had been rebuffed with records of the deceased, the complainant, from a private facility in Kerrville. My office has continued communications with them, and as of 2 days ago, they finally understood that the state of the deceased is not being attacked by this prosecution, and they will have agreed to release the records to me if I get a judicial order signed. I filed this yesterday in the name of defendant Flores. I've let counsel know. I'd like to urge this, and I will share with every defendant if they produce the records of the complainant's residence at Starlight Recovery. I don't believe it's dispositive of any issue, but I do know defendants are interested in it. And I don't mean, sorry for interrupting, I probably should have led with that first, Judge.
All right, Ms. Ferguson, this trial is going to take 2 weeks. Give me a jury trial setting for 2 weeks, please.
Yes, ma'am.
And would the court, once we have that initial setting, would the court be willing to entertain this case with all three defendants? Is specific to my docket. I already have a scheduling order on a different matter, same gravity in another court that I've got to try and align. Is the only reason I'm bringing it up.
All right, is that other case actually gonna go in the other court?
Yes, ma'am. I'm in the 437th with the LaHood firm, who's also co-counsel in this. We have a pretrial motion set in mid-September, and we have a firm trial date in November.
And which court is, you say the 437?
Yes, ma'am.
All right, we'll see if that goes. Ms. Ferguson, give me a date.
Would the court be open to scheduling orders? The parties had discussed whether we could get together, check the calendars of the experts, the witnesses and the lawyers, and propose a scheduling order to the court.
No, court is not doing a scheduling order for this. This is gonna be your trial date. If y'all have motions that need to be heard before trial, set it with Ms. Ferguson and the court will be available to hear it. All right, and y'all can set that. Ms. Ferguson, if they have motions, it can be set on a Friday. All right, September 24th.
So I'm hearing the court to say of the lawyer teams and the experts that have been retained in this case, we will not be afforded a chance to see if everybody's schedule can comply with that date. You're setting that as a hard date.
Yeah, it's September 24th. All right. Is there anything else?
Yes, Sharon, if I could approach with
Yes.
a copy of the order. And for the court's information, the order is obviously the last page. The attachment is the email and language from the Starlight Recovery saying they require the court order to comply with meet HIPAA requirements.
All right, here you are, counsel. All right, once you sign the reset form, you're all excused. Thank you.
Thank you, Judge.
0B, State of Texas versus Eleazar Alejandro. I'm working on it.
It's fine.
All right. Can I have parties announced for the record for the state
Daryl Harris for the state, Your Honor.
defense?
Mario Del Prado, and Mr. Alejandro.
I'm sorry, I didn't hear you.
Mario Del Prado.
And you're Mr. Alejandro, correct?
Yes.
All right. Have you all reached an agreement or no?
No, Your Honor.
All right, your jury trial date is September 24th. All right, once you sign the reset form, you all are excused.
Thank you, Your Honor. Your Honor, for the record, I know you've already, Mr. Nesbitt approached the court. We would request a special setting because this is a joint defense agreement. There's probably going to be several experts, potentially for each client. Mr. Harris was not opposed to a special setting at the very beginning of the year. We were hoping that the court would consider that. But
All right, I'll consider that. All right, I'll consider it. It's denied. You guys come back on September 24th. All right. Is there anyone else for the defense?
Patrick Valentine from Mr. Villalobos.
And are you Mr. Villalobos? All right. I'm assuming no agreement has been reached.
That's correct.
All right. So this will be set for jury trial on September 24th.
Thank you.
All right, you're welcome. All right, thank you.
But Boyd stood firm. On June 24th and again on September 4th, 2024, she denied all motions to delay the trial, even with family emergencies, missing digital files, or experts who couldn't attend.
why I did not look into you.
All right, so this is what the court is understanding. The court is understanding that this case has been on discovery for over a year. All parties signed an acknowledgement of discovery on May 30th, 2024, saying that they had everything. So with regards to now people saying, I don't have this, I don't have that, and it was listed in the acknowledgement of the discovery that you had it, you all need to confer off docket for that. Does everybody understand what the court is saying? All right,
Well, I do have a question here.
yes,
I hope the court understands
the third area.
Oh, please be seated. It makes it difficult for the court reporter to hear when everybody stands.
Yes, I hope the court understands the third area that's missing. And I understand you want us to confer about that third area. But if we don't get that, the bookmarks and the comments, would the court be receptive to another request for relief from the failure to produce?
Oh, well, here's the thing. If I deny the motions for continuance, then we will cross those bridges when we get to those bridges. But what I'm telling everybody is that when you sign an acknowledgement of discovery, it means that you are saying you have received the discovery. And I will tell you, the discovery acknowledgement says, e-discovery version acknowledgement. The parties hereto acknowledge the information has been disclosed pursuant to the district attorney's open file policy in hard copy form, as well as through e-discovery in the latest document versions identified as version 29 May 2024. And then there's, of course, the ongoing obligation to disclose. That was signed by all parties on May 30th. And the defense attorney who signed it in this case was Mario Del Prado, who you said is your co-counsel. So by signing that, everybody acknowledged that they've received it through e-discovery or hard copy.
Additional evidence goes beyond whatever is in that index, and that we were given multiple iterations of that index, each time increasing in document and exhibit number by the hundreds.
So what have you guys been doing since January? Because this discovery has been going on since January.
I can answer that question.
Yes.
There are
And also, what have you guys been doing since May? Because everybody signed the acknowledgement of discovery in May.
Does the signing of that discovery acknowledgement says what Mr. Harris says is on that index, we were given. And we all spent a considerable amount of due diligence verifying that what Mr. Harris said was on that index is in fact in the Veripic jumble. The arguments that were made, and so I guess to then answer the follow-up court's question, reviewing and going through the evidence, trying to synchronize, harmonize, analyze, further investigate, because there is a ton of it in this case. We all have multiple terabyte drives for this case. I think every counselor in this case would acknowledge that this is an incredibly evidence voluminous case, more so than maybe anybody else has seen in their whole career. And there's a lot more experienced jurists here than me.
Not me.
In the era of body cameras and technology and everything like that, it is very, very evidence heavy. So you can't watch my videos at the same time, right, Judge? There's an incredible amount of due diligence that goes into it while simultaneously trying to run a law practice. With that being said, I am not casting aspersions. I am just going to express my sincere worry about the complete package of the evidence in this case. Although, yes, we signed that what was on that index is in our possession, we come across things that are not in that index that are very important to this case. And in my motion, I gave you a prime example.
All right, and do you have co-counsel on your case as well?
I do. It's David Christian. He is back there, Judge.
Hello.
Officer Andrew Chernak was an on-scene officer who was part of the breach plan, who was pre-trialed by the state, who testified under oath in the grand jury, and appears to be central to at least the former prosecutor Darrell Harris's theory of the case. We received his pretrial notes, which is maybe in the ballpark of like 120 or 150 words total. But then he went into the grand jury and testified for a considerable amount of time. His exposure at the scene was a considerable amount of time, observations, reports, etc. We learned recently that Andrew Chernak had been emergency detained around 2021. He was taken out of active duty. There was an arrest in Hondo. There was a firearm. There was alcoholic allegations, all kinds of things that would be very interesting and right for cross-examination, credibility reasons, for evaluating Andrew Chernak and why he might be turning his testimony in this case.
All right, are you saying you don't have that information?
100% I am, nor was it presented to the.
State,
grand
give him
jury
that
or-
information, and you're to give him that information no later than Friday if it's in your possession.
But it's a touchstone moment, Judge, just like us learning that Officer Ramos and Officer Salinas had to sit out for medical reasons after this because they felt so bad about what happened. There's documentation to that. There's medical follow-up to that. But the touchstone of what I'm getting at is the duty to investigate goes into all of those individual things. And I think due to the volume and the disorganization on this case, I do not know if that duty to investigate has been fulfilled. And examples of those are what are coming out of Mr. Cifuentes and my mouths right now. And it is cause for concern. It's grounds for a mistrial. If Andrew Chernak was sitting on that witness stand right there, and it's just it's a good faith due diligence argument I'm making to the court that despite signing that discovery acknowledgement, that there's things that weren't in that index and there's things that weren't given to us. And we are feeling that relying on well, it's really disorganized, but I'm pretty sure I gave you everything. That's a very risky proposition when these gentlemen are going to go on trial for their lives. It's a very, very risky proposition. And I know the court is frustrated at the amount of
Now,
discoveries.
I'm not frustrated.
Okay, then,
I'm just stating facts.
okay. thank
Y'all have been here since January on discovery.
Okay.
So no frustration on the court's part. I'm just stating facts.
Well, that's my argument, Judge, when it comes to discovery. Additionally, or in the alternative, we have filed our original motion for continuance and a supplementary towards the court because maybe counsel wasn't detailed enough in our argument the first time. We didn't do a real good job of explaining to the court exactly the bullet points of 2906 and how they apply in the present case. So we duly filed a supplemental motion for the court's consideration on the issue of the expert. So on behalf of Alfred Flores, I'll go into our expert, who is Mark D. Sawa, a nationally recognized use of force specialist. We've attached an exhibit to our motion, which is his resume. Judge, he would be and is very much a material witness in this case. Every part of his expert opinion and testimony will go to the central issues of the case: tactics, police use of force, self-defense, deadly force during an arrest, police investigations, thoroughness, protocol, and the list goes on. He has spent considerable amount of time and hours reviewing the material and conferring with counsel. We have been in good communication with him at all times over the period of many months as we exercise due diligence in both communicating and keeping him up to date. He is unavailable for the court's present trial setting, and I elaborated on that in my motion. He has to testify in another trial, state of Texas v. Curtis Taylor. He has pre-booked travel and professional obligations that are cause for his unavailability. We have not made him absent by consent or our procurement judge.
And where in Texas will he be? Because you said state of Texas versus, so what part of Texas will he be testifying in?
I can find that out, Judge, and I do know that a lot of his travel is taking him to the Northeast for seminars and speaking engagements and things like that. But I can find out further where the state of Texas versus Curtis Taylor is. Judge, it's
So
hard.
here's the thing, when people want to throw out terms like reversible error, those already are like buzzwords. Judge, you're setting yourself up for reversible error. But here's the thing I want all the parties to understand about my rulings. I listen to what parties have to say. I make my rulings based upon the law, and whatever is within my discretion is within my discretion. I don't make my rulings based upon if this were to go up on appeal, what would the Fourth Court do? What would the Texas Supreme Court do? That is not in my purview. And so when people throw out terms like it's reversible error, or if it's harmful, thank you for throwing that out. That's what I will say.
It was with great trepidation, Judge.
Yes. But that doesn't, so that the state will know and that parties will know what the Court of Appeals or the Fourth Court may or may not do does not play a role in my listening to what the evidence is that you are presenting or listening to your arguments. The role that the Fourth Court plays for me is what was their decision on this case and what are the legal rules? That's it. What is the law? Did they interpret the law some sort of different way? What is it? That's all I'm focusing on, and hearing the evidence or the argument that you all presenting and reading your case law. But what other people may or may not do with my rulings, that's not what I consider.
And Your Honor, finally moving on to a new ground in this motion for continuance, and that's what Mr. Nisbet alluded to, the birth of the child of my co-counsel, Mr. Jason Goss. I didn't want to be pestering Jason on this day, but he did inform me last night that his wife's labor was going to be induced this morning, and that the child was expected to be delivered today. And as such, as he has declared prior to this, and for some months now, he will be engaging his family medical leave act rights and taking time off to both care for his toddler age child and assist his wife in the care of their newborn child. So congratulations to them. But Your Honor, that would make Mr. Goss unavailable during the presently scheduled trial date. And before Your Honor rightly asked me, do you have other counsel in your firm? We do, of course. But Mr. Goss is our trial specialist. I'm no trial attorney. I do all the motions work. I do all the research. I do the appeals and things like that. But Mr. Goss is actually the person we want standing before a jury. He's the person that Mr. Villalobos wants standing before a jury and making those arguments and making the cross-examinations during trial. Because he will not be available, we're positing that as another reason to the court why a continuance of this trial should be granted.
Well, and of course, then the granting of severance or not is also within the court's discretion. So maybe if he can't be here, then maybe you should be severed out from trying the case with the co-defendants.
That's a proposition I'll have to confer with Mr. Goss on.
All right. All right. Is there anything else from either side? Any more arguments? All right, defense, your motion for continuances are denied. We're doing jury selection on the 20th. I am aware, and I heard your argument, and I internalized your arguments with regards to your experts needing to hear testimony as they're excluded from the rule. As you all know, the court live streams, so they will be able to watch all of the testimony because it will be live streamed and they can watch that at their leisure. And with regards to experts coming to testify, the court will allow them to testify by Zoom if needed. All right, everyone. Thank you.
After the denials, the lawyers regrouped. They felt she wasn't just being strict, she was being hostile. Her courtroom was being live streamed on YouTube. Every frown, every sigh, every denial, broadcast for the world to see. They filed a motion to recuse Judge Boyd. Before the testimony even began, the courtroom dynamic had changed permanently. Judge Boyd's live-streamed hearings were gaining attention online. Her videos were being shared, clipped, even commented on by strangers. Lawyers testified that defendants were afraid to speak freely, knowing their cases could end up on YouTube. Some claimed it turned legal proceedings into public theater, where every objection, delay, or denial became viral fuel. They didn't just worry about losing in court, they feared being publicly humiliated.
One thing particular to this case is this one, because you'll see, it's a little hard to see, but that guy right there, that's Mr. Goss. So Judge Boyd rips defense attorney apart for prioritizing vacation over trial. That video has had over 25,000 views. I'd like to, just to give Your Honor an idea of what we're dealing with, and this will be the last I say on this matter, but here's an example, a video example of an actual hearing in this case that has been recut and redistributed and amplified due to Judge Boyd's insistence on conducting her daily YouTube show.
All right. Is there anything else from either side? Any more arguments? All right, defense, your motion for continuances are denied. All right, defense, your motion for continuances are denied. All right, defense, your motion for continuances are denied. We're doing jury selection on the 20th. I am aware, and I heard your argument, and I internalized your arguments with regards to your experts needing to hear testimony as they're excluded from the rule. As you all know, the court live streams, so they will be able to watch all of the testimony because it will be live streamed and they can watch that at their leisure.
So that's the world we're living in here, Judge. And I want to be clear, Judge Boyd is not producing any of this content, but she is producing the content which allows these creators to amplify these and make a circus of the trials and the proceedings in her court.
One defense attorney had filed a leave request under the Family Medical Leave Act. His wife was about to give birth. Judge Boyd denied it. In court, he described a pattern of what he believed was judicial hostility. He claimed she rolled her eyes, used dismissive hand gestures, and mocked the defense team during key moments. He pointed to one specific instance where Judge Boyd, after denying a defense motion, appeared to look directly at the camera, almost as if playing to the live stream audience. He argued the courtroom wasn't just about justice anymore. It was about optics. He said Judge Boyd showed visible bias, sarcastically dismissed arguments, and humiliated them in front of both jury and livestream. To him, the defense wasn't just battling the state, they were fighting a performance happening on the bench.
On this manslaughter case that we had just recently tried, because we didn't have some of those things that we have in this case and some of the other cases with the YouTube comments and everything else. But during that trial, one of the things that frequently occurred that concerned me was I was trying the case with Jasmine Holguin, who is an associate in our firm. She has been licensed in November, she'll be licensed for 2 years. And while I was sitting with Ms. Holguin on that case, I was told several times by Judge Boyd in front of the jury that I was not allowed to speak, that Jasmine was my lead counsel, and that I could not make arguments on the issue that we were trying to argue. Of course, I objected, and at the time the case worked out for us, but I had issue with that, and then I had to basically transmit arguments and things on some of those issues through counsel, through Jasmine, which told me, just based by her conduct in that case, that she was not treating me as she would treat other lawyers who are senior lawyers who are sitting on the case and should be allowed to make arguments on behalf of their clients. And that occurred last month. So that case was what was happening last month.
If you look on the screen, I have a slide I displayed earlier. Is that slide and the video clip that accompanies it, is that from the case you're talking about?
Yes. Yes, I had to come in as counsel because one of our other counsels who had informed the court that he was on a non-refundable vacation, the court started the trial anyway, knowing that it would not be done a week, and she was told it would not be done a week. She made our associate and Jasmine go to trial. Subsequently, when the case did go longer than a week and he had to go on the vacation because it had been planned for over a year, and it was non-refundable, I came in. I had to come in because there would only be left with Jasmine, who had not tried a manslaughter, who was not. She is a very capable lawyer, but she is a very capable lawyer and a great lawyer at the beginning of her career. So in that clip, Judge Boyd grills me for about 9 minutes, ultimately bringing the jury in, asking them if they recognize me, and then allowing me to sit. Only after I went through this this performative, I think, questioning, and honestly with the intent to disparage or humiliate me, she finally allowed that. after going through all of that. Notice of
My
appearance.
question is, why were you not present during jury selection? This is the first time that you have been a part of this jury trial. So my question is, why were you not present during jury selection? Why have you not been present during the state's case in chief? Why are you just now making an appearance?
Yes, Your Honor. So I had other matters that I had to attend to. This was Mr. Hillier's case along with Ms. Olguin. The state represented to the court that it would be a 3 or 4 day trial. Mr. Hillier repeatedly tried to tell the court that it would not. Mr. Hillier repeatedly asked for continuances based upon this vacation. Mr. Hillier put in a vacation letter and told the court that if it went longer than last week, then it would run into his vacation. That he
And a
could not-
vacation letter does not a motion for continuance make. And this was the date that was chosen by the parties. This case had been reset before because counsel said he had a CLE to attend. So the court gave him time to attend his CLE, and this is the date that both parties chose.
And the court
And he's in the middle of a trial. And then we go back to the question is, if you're going to be his attorney, why were you not here during any parts of this trial? This is the first time that you've appeared to sit. And if Mr. Hillier knew he was not going to be here, why did he not have you qualified before the jury? It would have been a simple matter of his asking the jury, we're going to have Jason Goss who may come sit with us. Does anybody know Jason Goss?
Mr. Hillier believed based upon when the court set this case, if the court remembers, the court set it for last Monday. The court decided not to go to trial last Monday.
Because he said that he had a CLE to attend where he was seeking to obtain his board certification.
No, Your Honor, the week before. That was the week before. Last Monday was when this trial started. The court told the parties that they would start on Monday and be here Monday. The court decided not to start until Tuesday. Had the court started on Monday, Mr. Hillier would have been here today. I mean, the case would have been over on Friday.
Mr. Hillier had a choice to make. He chose to go on his vacation.
Your Honor, the reason that there are vacation letters is because the courts have recognized that it is not a choice when somebody has a family, when they have non-refundable tickets, when they have plans that have been made for over a year's time. In addition to, he is not in a position where he could join them late because they are on a ship in the middle of the ocean. So he is not in a position that he could leave his family.
So you're telling me that cruises do not dock in different places?
They perhaps dock in different places, but he could not make half of the vacation with his family and was not willing to have his family go along without him. And that is why there are vacation letters. So the defense is asking for a continuance to allow Mr. Hillier back.
Oh, that's going to be denied.
I understand. And additionally,
And have you filed a motion for continuance?
defense is asking for a continuance from the court at this time based upon these circumstances.
So you have not filed a motion for continuance, is that correct?
We will file a motion for continuance.
No, my question is, have you filed a motion for continuance?
The motion for continuance was filed before and it was denied. And
Have you filed a motion for continuance? We're in the middle of a trial. Have you filed a motion for continuance now?
we have not, we will,
That will be denied.
yes, Your Honor.
All right, so the issue is whether or not, state, do you object to this council being present?
Yes, Your Honor, the state objects.
And based, as I argued before, they do not have the right to have a question about whether somebody on the jury might recognize me or look at me and know who I am. That right does not supersede my client's right to counsel of his choice and to effective representation of counsel.
Well, the counsel he chose was obviously Mr. Hillier because he was here, Ms. Olguin was here. So those are the two counsels he chose from your firm. And we're back to the point. Why did you not appear for any stage of this trial before now?
Because the court and the state represented that the case would be done last week, and it was not. So based upon those representations made by the state, 3 or 4 days, which is on video and on the record, and the court, who believed that it would be done last week, I had other settings that I had to go and appear at. And so
Other settings that were jury trials?
other settings that were potential jury trials that didn't turn out to be jury
So
trials.
not jury trials.
Not jury trials, Your Honor. However, in this situation, the state objecting in this situation to me sitting and assisting Ms. Olguin that right is so low on the totem pole compared to his right to allow me to sit here and assist Ms. Holguin.
So hypothetically, let's say somebody from the state's office were to come down to sit there and they haven't been qualified before the jury.
Right.
And you say, oh, that's fine. And then we discover, oh, their mom is on the jury.
Right.
That would be fine with you.
Well, I know my mother's not on this.
No, that's my, I'm giving you a hypothetical.
State does not have a constitutional right to
I'm
counsel.
giving you a
State
hypothetical.
does not have a Sixth Amendment right to
So
counsel.
let me ask you this. So let's assume your mom is on this jury. Do you think that you should still be allowed to sit? Let's assume one of your best friends is on the jury. Do you think that would be a fair trial for the state for you to sit?
I think.
Yes
that-
or no?
I think that their issue with that would not outweigh his Sixth Amendment right. It's a
Okay.
constitutional right versus the state's disagreement or some possibility that does not exist.
Mhm.
So no, my mother and my best friend are not on this jury.
Well, you wouldn't know that.
Well, so I would definitely know if my mother was,
Mhm.
right? So, and she's not, because I know where she is and she's not serving on this jury. As far as the other balance, it's just a balance of rights. I mean, I am here, I am willing to assist Ms. Holguin. It is important for my client's rights and the Sixth Amendment right to allow me to do that.
All right, are the jurors present? All right, let's line them up.
So I've been contacted by the Judicial Conduct Commission. They've asked me for evidence. They've asked me for everything that I have, which I have provided. A lot of the screenshots of the comments that the trial court was allowing back at the time, and the disparaging comments towards members of the legal community generally, but specifically to us. Xenophobic comments that one of our counsel who was born in England or in Great Britain should go back to his own country, and all of these things were on her own website or on her own YouTube channel. And so I provided all of that to the Judicial Conduct Commission, and my understanding is that they have it and they are continuing to investigate. And I've just told them I'm available for any other issues that they may need.
And did any organizations make any efforts in support of your complaint?
Yes, I was asked by SAGDALA to present my complaint to the executive board of SAGDALA, who all agreed and then filed their own amicus brief, basically, as well as their own judicial conduct complaint, citing the things that I cited and a few additional things, where they mainly focused on the fact that she was leaving up trials of defendants who had been acquitted and therefore expunged, which would violate the statute against publishing expunged cases, and really subjecting those defendants who had been acquitted to further ridicule for terrible offenses that they've been charged with.
And just for the record, SACLA is the San Antonio Criminal Defense Lawyers Association.
Yes.
I want to ask you about the previous recusals. Judge Harrell's very familiar with that, so we didn't need to go into the substance of them. But since those recusals have been granted, when you have had occasion to go into the 187th District Court, or when the other counsel in your firm have gone in, has there been any change in her behavior?
Yes.
Can you describe that?
She has, as I described with the trial that I had to come in on last month. I've never before been told that I cannot argue on behalf of my client, making valid legal arguments, and that I had to transmit my arguments through another person. And this would be arguments that weren't on a person's witness or something like that. Additionally, she has been cold. She has been insulting at some times. She has said, she has made hand gestures towards me when I'm speaking, like to make me be quiet. She did that in front of the jury. She has treated me as if she is angry or upset with me because of the basis of my grievance.
Well, let me ask you a question real quick.
Yes.
Have you had discussions with her about the grievance itself, or did you give her a copy of the grievance?
I didn't.
So she's never acknowledged to you herself that she's aware of the grievance is pending? To you personally?
She has not acknowledged to me personally she is aware that it is pending.
Has she acknowledged it to anybody that you're aware of?
I understand that the grievance committee contacted her to preserve, because I had asked to preserve the videos and the comments so that they would not be deleted once she was, and I understand that that has happened.
Okay, thank you.
And have attorneys in her court, attorneys from our firm who have appeared in her court been made to wait till the end of docket before they could be heard?
Yes,
And sometimes the entire morning,
yes,
and sometimes recalled into the afternoon?
into the afternoon, yes.
So, Mr. Goss, first of all, I've congratulated you, but on the record, congratulations on the birth of your daughter.
Thank you.
Okay. Prior to your daughter being born and subsequent to your daughter being born, have you sought continuances based on your Family Medical Leave Act leave in other courts?
Yes.
Have you ever had any court deny you a continuance on that basis?
No, and I've never heard of any court ever denying any attorney on that basis.
Now, Judge Boyd made the suggestion that, well, we could sever our client out and then you would be able to try the case when you return from your leave. Why is that not an acceptable solution?
Because the reason we have the joint defense agreement is because we all believe that it is in our client's individual best interest to have the case tried together, in particular because we each have individual experts for our clients, but we are each counting on the ability to use the other defendant's experts to support our case, as well as if they testify, they are going to testify as a joint front. And we believe that, especially with Nathaniel Villalobos, because of the particulars of that case, and as you can see, he's been charged with something different, we believe that it is important that Mr. Villalobos be tried together with everyone else so that all of their actions can be considered by the jury at the same time, by the same jury that all of us have picked. And we have met multiple hours. We have gone to the evidence room together as a group, meaning all three defense attorneys, or all three groups of defense attorneys. We have strategized. We have with each other for the last, since the case was indicted in December of 2023. And without, so it puts me in a position of having to advise my client, either you get me or you get your best defense. And it's an untenable position to put me in as an attorney, because I have to take care of my child and my wife and all of those things. And my client has to have the best defense that's available to him. And we have all determined that that is as the group, and that's why we have joined. And that's why we have a joint defense agreement.
Mr. Goss, concerning the grievance, is the fact that you filed a grievance against Judge Boyd common knowledge in the criminal legal community of Bexar County at this point?
Yes, it's been reported in the news. The Sagdala grievance was, that part of the grievance and the fact that it contained me has been reported in, I believe, San Antonio Express News and KSAT. I did not speak to any news organization about it, and I did not make comment about it personally, but I know that Sagdala did.
And do you believe that Judge Boyd has exhibited a personal bias towards you in this case and in other proceedings since that grievance was filed?
Yes.
What's the remedy for violation of the Family Emergency Leave Act?
I'm not sure.
Just curious.
I don't know. I've never heard of anybody violating it.
I mean, I've seen the statute with
Yeah.
it. Judge, I apologize. Could you step out, because I don't want them to try to call you.
Sure. Thank you.
All right. Okay, what else we got from Mr. Gospel?
Mr. Goss, you were a prosecutor for a defense attorney?
Yes,
How long were you a prosecutor?
for 9.5 years.
How long have you been a defense attorney? About 6 years, right?
January 2019.
Okay.
Yeah.
In all your years practicing, have you ever seen a judicial officer deny a properly framed and filed motion for continuance under 2906? That was not brought on the day of trial?
Yes, I have seen it. I have seen it one time, and it was reversed.
And has any other judge in Bexar County or the other counties you practice in denied continuances for you on that basis?
No.
Another perspective came from Tom, a defense attorney and former prosecutor. He testified that Judge Boyd's courtroom lacked flexibility and mutual respect. He said that under her watch, defense attorneys felt micromanaged and humiliated. He emphasized that trials were no longer collaborative. Boyd ran them like performances. Tom wasn't arguing that Boyd was corrupt, but he did believe her control over the courtroom, combined with the live stream, created a toxic environment for any defense attorney trying to do their job. He also testified that Judge Boyd once changed a ruling after speaking with her mother, who was watching the live stream from Louisiana. He said Boyd even had a large screen set up in her mother's house to view her courtroom appearances.
Were you a prosecutor with Bexar County DA's office?
I was employed with the county from 2008 till 2022. I was a assistant district attorney here in Bexar County from late 2009 until January of 2022.
And what was your last assignment in the office?
My last assignment was I was the criminal trial division first chair of the 187th District Court. This court, that chair that you're sitting in right there in front of Judge Boyd. From starting, I was asked to audit the court's docket in April of 2020 and officially moved into the court August of 2020 because of COVID through January 22nd of 2022.
And as in your capacity as first chair in the 187th District Court, you obviously had many occasions to view Judge Boyd's conduct and the way she handled various matters, including continuances, correct?
Yes, sir. On a daily basis. This was a court that stayed open during COVID. Interestingly enough, I was witness to the genesis and rise of the use of Zoom and subsequently YouTube in this courtroom with this particular judge. But to answer your question directly, hundreds of cases across weekly, monthly, yearly basis being handled of all different types in this court in front of Judge Boyd.
Have you, now let's take a serious case, a complicated case, a murder or something else that is more than your average felony case. Have you seen Judge Boyd deny a continuance on a case that's less than a year old and force the defendants and the state to trial such as she's doing in this case?
No. And I spent some time looking back through names that I remembered off of the docket, and never a first trial setting. A first trial setting would never be denied a continuance, even if it was a sort of Bexar County special impromptu oral one at the bench, let alone 3 to 4 written, verified, detailed, perfected first motions for continuance under 2906. Never saw it.
So were you in the court when the YouTube thing started?
Yes.
Okay, can you talk about whether that you saw a change in Judge Boyd's judicial behavior upon that evidence?
I would say yes. The technology curve improved here in Bexar County as a whole, but this particular court used the picture-in-picture frame to show the judge while it's also showing whichever litigant was speaking at the time, which is unique and different than other courts. And that the fact that You get gently reprimanded based on how you move around in the courtroom to try to keep you within the camera shot, which is in the well. If you turn your back to the camera, you're told that the court reporter can't hear you, but she can. Things like that.
Can you tell us about the scene that Judge Boyd sets every morning with regards to the camera that is facing her?
Sure, she goes through her comments, right? She sets up her handbag next to her flower display, and she goes through a series of, I'm going to call them ovations. Most have jest packed into them to get laughs, either online or in the courtroom, before she actually calls the docket and begins serious business.
And have you ever known Judge Boyd to have her rulings influenced based on who might be watching the YouTube videos?
Yes.
Can you talk about that, please?
There was a case that should have been a VTC acceptance.
And that's Veterans Treatment Court.
Yeah.
Correct.
The case actually belonged to Mr. Goss. The judge was going to, I think, grant a application for probation. And I'm going to say after something influenced her decision, she changed it and she sent him to TDC afterwards, I think for 4 years.
And do you have any knowledge of what it was that changed her decision?
I think it was a phone call to her mother.
Why would
I'd
you
like
call-
to speak to that a little bit.
Yes, sir.
It was known to me that part of the YouTube genesis in this courtroom was installing a big screen TV on the wall of the judge's mom's house back in Louisiana so she could watch her daughter in court every day, kind of like a TV show. And that it began to create content, and that the content obviously started to take off online. And so it was my impression that the TV show, as it were, and somebody watching at home influenced the outcome of that punishment trial that day.
And I think you said that was the case where Mr. Goss represented the defendant?
Yes.
Okay. In all of your experience, both as a prosecutor every day in this court and as a defense attorney who frequently appears in this court, have you ever seen Judge Boyd treat any other defense attorney the way that she has been treating Jason Goss for the last year?
My answer is no, and if I could expound on it,
Yes.
I think, and it's probably gone after this, but I had a lot of goodwill with the judge. When I was her prosecutor, I improved her docket numbers significantly and placed her into a high-ranking position against the other district courts. And I always enjoyed a professional, respectful treatment from her as a DA, as I did when I would come in here as a defense attorney, beginning in January of 2022. And I have never experienced anything remotely close to what's been going on in this case by another judge as a DA or a defense attorney, or certainly by this particular judge in this case.
So do you feel that the lack of impartiality or the personal bias that Judge Boyd directs at Mr. Goss has now extended to you and your clients?
Very much. I think the stain or the creep has made it into Mr. Cifuentes' client. It's made it into obviously Mr. Goss's client, and very much for our client, Mr. Flores. And it's going to affect a very serious matter that's very important to the community, for all members involved, and at least the appearance of the partiality and the bias is there, in my opinion.
As an officer of the court, bound to tell the truth here, I'm just going to ask you directly, do you believe that any of the defendants in these cases can receive a fair trial from an impartial jurist in front of Judge Boyd?
I do not.
The lead prosecutor also took the stand. He didn't accuse Judge Boyd of bias, but he admitted the courtroom tension was real. He acknowledged her courtroom was moving fast, maybe too fast. Even the state had been denied a delay.
Now, since coming on to this, first of all, let me kind of ask you, would you describe this as a complex case?
Absolutely.
Okay, what do you think makes it complex?
I would say it's three complex cases that have been joined together. And what makes it complex is multiple factors, but the indictments in the case, I think it was one of the first slides you put up, there's multiple counts with multiple defendants, and so that is really something that requires some time and some care to review the indictments and make sure that they comport with the anticipated evidence, make sure that the wording is correct. The jury charges in these cases based on the indictments are going to be very complicated. Further, what makes this really a complicated case is the fact that anywhere across the country, charging somebody that was discharging duties as a peace officer at the point in time when they are then facing criminal charges for that conduct is exceedingly rare on a relative basis. Relative to caseloads across the country, charging somebody that was at the beginning of their shift on a day that they end up facing a charge, acting as a peace officer, it's a very rare thing, and there are unique defenses that are very complicated that relate to somebody that was working at the time of the alleged conduct as a peace officer. Peace officers have much more kind of complicated defenses that they can assert than a layperson. The fact that these cases are being brought together, which I was vehemently objecting to until such time as your clients all started giving very personalized waivers of their rights to confrontation. And so until that happened, I didn't envision that it was reasonable to proceed with a joint trial. But after that happened, then it really resolved a good number of the concerns that Mr. Lunan, Chief Lunan, and I would have as prosecutors. But that was only recently, so it's only been in the recent past that we've been analyzing this as a joint trial for 3 officers at the same time, where the charges include but are not limited to allegations of murder as presently exists in the indictments of Sergeant Flores and Eleazar Alejandro. Yes, what's potentially Brady to one what's potentially exculpatory to one may be potentially inculpatory to another, but these are 3 individual human beings that have been accused as a result of the separate indictments in this case, and Brady is at stake with the ongoing discovery that is happening. I can tell you that Chief Lunan and I and the other members of the team who are aiding and facilitating us in our efforts to get on top of this pile as quickly as possible, we determined thus far through the course of our investigation that it was highly likely that there was spent slugs that had been collected and not yet tested by the serology section of the medical examiner's office, or evaluated by the ballistics section at the crime lab. And we further formed what we believe rises to the level of probable cause to believe that there was a spent slug inside of a wall that has never been recovered, and at our direction and under our control. And just Friday, through a search warrant that we were directing to be acquired, a wall at the scene of the alleged offense was broken into, and they did in fact secure a spent slug. I would say that the best evidence of what I brought to Judge Boyd's attention is the record from the initial motion for continuance and any statements that I or my co-counsel made at that time, plus the verified motion that we caused to be filed itself. I don't really recall, and much of this investigation that I've been talking about in my very most recent testimony had not yet occurred at that time. The reason it had not yet occurred is because Chief Lunan and I were still in the early stages of our evaluation of this case, and we had not yet got to the point where we realized we have potentially access to potentially exceedingly significant evidence that has not been evaluated and needs to be for the sake of everybody. In 30 years of having things happen in my periphery that I may not recall at this point, it is possible, but my memory is I have no recollection of ever having witnessed such a thing. It is possible that it occurred not to me, but in my presence or view, and I have forgotten the same, but I don't think so.
I'm going to ask you a question I don't know the answer to. It's the same one I asked Mr. Goss. Is the fact that he filed a judicial complaint against Judge Boyd, is that more or less common knowledge in the Bexar County criminal community?
Consistent with what I said earlier, that I don't generally try to pay attention to something that is not directly relevant to what is on my plate, I will tell you, I did not know until we were in this case and it became a relevant fact of interest to me. So I'm probably not the best person to speak to what the community generally knows, but I was previously, I believe in 2010 or 11, the president of the San Antonio Criminal Defense Lawyers Association, and that association is active, and at least back then there was over 400 members, and they are vocal, and this would be something that would be of note to them, of interest to them, discussed among themselves. And so based on my knowledge of this core group of 400 people, I can't imagine that it hasn't been discussed up and down the hallways of this building on numerous occasions by dozens, if not hundreds of people.
I'm going to ask you, I'm not going to ask you whether you believe Judge Boyd is impartial or partial or biased in this case, because that's not even the standard here. But you seem to be a reasonable man. And I'm going to ask you as a reasonable man, do you harbor doubts as to Judge Boyd's impartiality with regards to Mr. Goss or any of the people on this side of the courtroom?
I am mindful of the standard of review, and as a prosecutor, listen, not to draw unwanted notice, but we have next of kin in the courtroom. I have an exceedingly strong interest in multiple parties, almost most assuredly to include the next of kin, to not have to have a significant risk of enduring a second and subsequent trial just to get to the point of having a single conviction that could be maintained. And of course it's all speculative until you go to trial, so I'm not making a prediction as to the outcome, but the way it's presently poised, I am very concerned, knowing the standard, that this is one more area that if we were to proceed to trial with the elected judge of the 187th, it is one more issue for me to have some very significant concerns about the possibility that this works or operates along with other possible factors to make a conviction, should there be one, be a conviction that is not able to be maintained.
Judge Sid Harley heard the testimony and made his ruling on September 26, 2024. He said, "I cannot see where it would be fair or efficient to keep her on the case." Judge Stephanie Boyd was officially recused.
The 187th with other motions. Each motion my rulings are based on the specific facts of that motion, just like the other matters we heard. And I granted those recusals, again, case-specific, fact-specific. In this particular case, I started off with, I am the regional presiding judge for the 4th Administrative District, and my statute says my job is to make sure efficient, orderly, and fair administration of justice occurs in the 4th Region. And I cannot see where it would be fair or efficient to allow this case to go forward with Judge Boyd presiding over it with all of the various things we've heard, and frankly, to safeguard the bar cards of the lawyers involved, to avoid putting the next of kin families through another trial. I think without commenting on the specific merits of the allegations against Judge Boyd, I have to grant the motion to recuse just to ensure that the fair administration of justice occurs in this case. So the motion will be granted, another judge will be assigned, and a docket control order, scheduling order will be set up with that judge as soon as possible.
The case was reassigned to a new judge. Trial was delayed. Melissa's family continued to seek justice. Civil lawsuits hit roadblocks, and the criminal proceedings remain ongoing. Judge Boyd returned to her regular courtroom, and yes, she kept live streaming. In a justice system where judges are expected to lead with balance, even the strongest courtroom presence can become the center of controversy. This is what happens when the lawyers fight back.